So, what to expect at an expedited hearing or an expedited trial? So, the situation is you don't have an attorney. The insurance company likely does have an attorney, and one of you has filed a hearing for an expedited trial. So, it has to be a dispute generally over medical treatment authorization, temporary disability, or perhaps a panel dispute. 99 times out of 100, those are the types of disputes that get heard at an expedited hearing. So the situation is basically that from the injured worker's perspective, most of the time, the judge needs to hear this right away. This isn't something that should be set for a settlement conference, then get set for trial, with trial to take place down the road. It's something that needs to be heard right away. Temporary disability isn't being paid. Medical treatment isn't being authorized. So one side or the other files the declaration of readiness to proceed. That side has to lay out the dispute that is at issue and the attempts that have been made to try to resolve it. So in other videos that we have, we lay out how you fill out a DOR to an expedited hearing and what you list on that DOR. What to expect when you get there. So things are a little different these days under COVID. In the good old days, we would always go down to the board for an expedited hearing. These days, the situation is changing. Just a few weeks ago, the board started having attorneys and parties come back to the board for an expedited hearing. So at this point, as of this filming in January 2022, we are handling expedited hearings at the board again. So you need to expect that you are going to go to the board on the day of your expedited hearing. Ideally, you will have filed your exhibits ahead of time. We've gone over that in another video as well. You and the attorney for the insurance company are going to have to go through the pretrial conference statement, lay out the stipulations, the issues, your exhibits. We went over that in another video as well. Go find that video. Then, what to expect at that hearing. The judge generally is not going to want to have the trial go forward. The judge, he or she, will want to talk to the parties and try to work out some sort of resolution with regards to your dispute. So, ideally, the judge will be able to do that. He will have the insurance company attorney call the adjuster. The judge will talk to you all in the same room, all at the same time, so there's no ex parte communication. But the judge is going to want to talk to both sides and see what he or she can do to work the issue out. And I will tell you, probably 9 times out of 10, probably higher, a resolution can be reached on the issue. Maybe the defense agrees to authorize that one limited treatment if there was a dispute over it. Maybe the insurance company agrees to pay temporary disability for a short time, but you have some sort of agreement with regards to a credit if the medical examiner comes back and says you are permanent stationary. There's a lot of creative ways to take care of that. However, the judge's goal is going to be to get the two of you to work out the issue with an informal resolution and have the matter go off calendar. That's what you need to expect when you go in, because the judge isn't going to want to go on the record and go through the trouble and the work of a trial. So the judge is going to want you to try to work that out. The judge is going to want both sides to take steps towards some sort of middle ground to work that out. If that can't happen, then you need to expect to go on the record at that time. It's an expedited hearing, so whoever requested it has explained that this has to take place right away, unless the judge converts it to an MSC and continues the matter so that it can be set later. If that happens, you'll get a continuance, but if the expedited hearing goes forward, you need to be ready to go on to the record. You need to be ready to present any witnesses that you have. You need to be prepared to have any questions laid out for those witnesses. If you're going to testify, you need to have a limited testimony only on the issues that are really at dispute. Be ready to go on the record for that. If they're bringing witnesses, you need to be prepared to cross-examine those witnesses. If it's starting to sound like a lot of work, it is. There's a lot at stake in an expedited hearing because it truly is a trial. If you're starting to get anxious about that type of thing, you might want to reach out to an attorney before you get to that stage of getting to that expedited hearing, because you do need to be ready to go on the record. So let's say the judge has met with everyone, can't work out a settlement. You go on the record. The matter is submitted. What will happen then? Everybody goes home, and the judge will then have time to issue a decision, and he or she will issue a findings and award or a finding and order with regards to whichever side may prevail. So that's what to expect if you're going to an expedited hearing. First, the judge is going to want to settle. If that can't be reached, if a no agreement can be come to by both sides, then the judge is going to likely go on the record. If there's no continuance, if it's not converted to an MSC, but the judge is going to go on the record, and you need to be ready for a trial on that date. You need to have your exhibits, if not already filed. You need to have a copy for the judge and for opposing counsel, and all of that needs to be ready when you go walking into the courtroom. If you have other questions with regards to what to expect or other issues with workers' compensation as an unrepresented injured worker, drop us a comment down below. We'd be happy to answer any other questions, film additional videos for you.